Good morning, ladies and gentlemen. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the jail for April 1st, 2025. We will start with the arraignment calendar. I think that's a very short arraignment calendar today. Then we'll go to the jail calendar. If you have an attorney who is representing you, your attorney will speak on your behalf. If you are not represented, then we'll talk to you at the time that we address your case. I see iPhones. iPhones don't help me tell who's who. So if I'm looking for somebody and you're having any technical issues, if I call your name and you don't respond, then if I don't see your name on the screen, I'm going to go ahead and automatically do a bench warrant. So if you could rename yourself, activate the screen next to where you see you should be, whichever iPhone designation is yours, and click on the box in the corner. You should see a box with 3 white dots. Click on that. When you see that, there'll be a pull down menu, and at the bottom of the pull down menu or somewhere on that menu, there'll be rename. Go ahead and rename yourself, okay? Because iPhone doesn't tell me anything. All right. So in a moment, we'll do the jail calendar, the arraignment calendar for today. Yes. All right, we have Clifton, Nakia Q. Clifton on the arraignment calendar, and that's the only case I see.
Yes, Judge. I scheduled Ms. Clifton. That's going to be a negotiated plea today. We are going to ask the court to take that under first offender, but she also is in bench warrant status. But I think we resolved the case today. That shouldn't be an issue. I don't know if we need a bench warrant withdrawal.
All right. So, Ms. Clifton, may I see you? Ms. Hagler, are we ready to go forward? Ms. Ponder?
I think it's Ms. Hagler on this one.
Okay. Ms. Clifton, may I see you, please? Start your video.
Ms. Clifton, Ms. Clifton, camera on, please.
She's not muted, so I don't know what's going on.
Ms. Clifton, can you turn on your camera? I can send her a text.
Please.
That'll help. But...
Okay, sorry. I was having technical difficulties. Sorry.
All right. All right, Ms. Clifton, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you're before the court on State of Georgia versus Nakia Q. Clifton. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is here on the call with you. Mr. Lynch has indicated that you're taking a plea today. Mr. Lynch, it is my understanding that she's entering a plea under first offender to which of the charges? Count 1 is simple battery, count 2 battery, count 3 obstruction of an officer, and count 4 disorderly conduct.
It's counts 2 through count 2, 3, and 4, Judge. Count 1 will be null pros pursuant to the plea.
All right. By entering a plea of guilty to counts 2, 3, and 4, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Ms. Clifton, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about November the 15th of 2020, Officer Gray was dispatched to 4820 Massachusetts Boulevard, College Park, Georgia, Clayton County, in regards to a verbal dispute taking place inside of room 302. Upon Officer Gray's arrival, He heard a loud female voice yelling profane language. At that time, he made contact with the front desk clerk, and she advised that a fight had taken place inside of room 302. As the officer made his way to room 302, he was met by two females. The victim is Andriana, Andriana McClinton, McClenton, and the witness, Miss Larron, Larron, Brack, Brack. The victim stated that she was just attacked by the defendant, who was the renter of room 302. The witness, Miss Brack, stated that she did witness the entire incident. She advised Officer Gray that the victim was asleep on the bed when the defendant jumped on top of her, attempted to make out. At that time, the witness advised that the victim tried to push the defendant off of her, and that is when the defendant struck the victim in the face. The victim did strike back in self-defense. During the officer's investigation, the defendant was determined to be the primary aggressor. The officer did arrest the defendant. As part of during the arrest, the defendant had tried to kick the officer as she was in the process of being arrested and being transported to the officer's patrol vehicle. Your Honor, those are the facts of the case. Your Honor, count one will be non-pros, count two, 12 months probation, 40 hours of community service. The defendant is to have random testing and drug screens, no drugs or alcohol. Count three, 12 months probation to run concurrent with count two, a fine of $200. And count four, 12 months probation to run concurrent with counts 2 and 3, and a fine of $100. The probation can terminate upon completion, and the defendant is to have no contact with the victim in this case. Miss Andriana, Andriana McClendon, McClenton.
Mr. Lynch?
Judge, I would ask that the court take the plea as negotiated, but take it under first offender. Ms. Clifton is eligible. I believe this is the only arrest that she has on her record. I would ask that you, from speaking to Ms. Clifton, she's way past this situation. She has taken responsibility for what happened. And so we would just ask that the court grant her first offender and accept the plea as negotiated.
All right. How long ago was this?
This was in 2020, Judge.
Okay, so Miss Clifton, I'm sure you have grown since then. We're clear?
Yes, ma'am.
All right. The whole basis of a relationship is you don't bother anybody unless they want to be bothered. So I'm sure you have learned that by now. And just make sure that you remember it from now on. I'm going to accept your plea under first offender. Your attorney, I'm sure, has explained to you the benefits, the pros and the cons for first offender status. So please make sure that you successfully complete the probation requirements. The probation officers here are amazing, and they will help you to successfully complete if you do what you're supposed to do, which is to show up for your probation reports and to make sure that you comply with all of the terms and conditions. Now, they have agreed that this will terminate upon completion. So the sooner that you get the special conditions of probation done, then this will terminate, but you're to have no contact with Andriana McClinton. All right, so on count two, 12 months probation, 40 hours community service, no alcohol or drugs, a random screens for alcohol or drugs. Did y'all say a substance abuse treatment in any okay, no. Okay, so screens for alcohol and drugs. 12 months probation on count 3, $200 fine. The $200 fine with the surcharges will be $298. And then count 4, 12 months probation, $100 fine. The $100 fine total with the surcharges will be $151.50. Counts 3 and 4 will run concurrent with count 2. Count 1 will be no pros. Ms. Clifton, I'm going to put you in a breakout room with our probation expert, Ms. James. Please make sure you ask her all of the questions that you might have based on your current situation, your work life, your transportation, all of those things. But the most important thing is that you do keep in touch with probation and do your reports, because your probation officers can raise issues if they feel like you're struggling, or if you need the court to reassess something, they can bring that up to us on your behalf, and they do fight for you, but only if you're going to make sure that you're doing what you need to do. Okay.
Yes, ma'am.
All right. Anything else, Mr. Lynch?
No, Your Honor.
All right, so Ms. Clifton, I'm going to put you in a breakout room with Ms. James. Once you finish speaking with Ms. James and you get signed up for probation, you do not have to come back here to the main room. You are free to go and begin your probation, okay? But like I said, the quickest way to mess up your first offender and to mess up on probation is to not report, all right?
Yes, ma'am.
All right, so I'm going to open the door for the breakout room, and you and Ms. James can speak at that time.
Mhm.
All right, thank you. All right, so next is the jail calendar.
I'll get you to. Everybody.
All right, the first case on the jail calendar is Maurice Lamont Bender. Maurice Lamont Bender.
Judge, we're still waiting for Mr. Bender to get up. He's not up here yet, so we do need to have some additional conversations with Mr. Bender. I believe I've spoken to him and I do anticipate a plea, but we need to have another conversation once he gets up.
Okay, Anthony Jerome Bowie.
Judge, I have spoken to Mr. Bowie. If I could just hold for my announcement on that case, I need to have another conversation with him.
Okay, Nasir Brown.
Judge, I believe that person has made bond, just no longer in custody. If I know he's not on the inmate list here.
Okay. Preston Keme Collier.
Judge, that was continued from the previous jail calendar.
Which means we should be ready today.
Yes, Judge. You will either have a plea or a order for an eval before you today, unfortunately.
Okay. All right, I got you. All right, Judy Lynn Crockwell Lewis.
Do we have well, we haven't spoken to her yet, Judge. We haven't spoken to females today yet, Judge.
Okay. Lee Leon Good Jr.
Judge, that's going to be a negotiated plea today.
Okay. Lakia Langford, that's closed.
Is he here for? She here for VOP or?
I don't see an SSD. I don't see a VOB. It just says closed.
It was transferred to Superior.
Oh, okay. All right. Antoine Marquise Martin.
Judge, we did submit a withdrawal due to a conflict. Unfortunately, our firm does have a conflict that happened during, well, we have a conflict at this point.
All right, Ms. Val, can we appoint conflict counsel for Mr. Martin, and let's hold him for a week till we can get that set up. Thank you. Marquise Antoine Mitchell.
Judge, that is going to be a negotiated plea today.
Okay. And Ramos Yesenia Isabel Ramos.
Um,
That's a petition.
we'll have to have a conversation with Mr. Ramos. Is Mr. Ramos up yet?
It's a miss.
Sorry, Ms. Ramos. So we haven't fully advised her yet, Judge.
Okay. All right. So it sounds like y'all need to talk to people.
That's right, Judge.
Okay, so I'll give you a few minutes to talk to people, and then when we come back, let's be ready to rock and roll.
Well, Your Honor, did you want to go ahead and do good since we're ready on that one?
We can do that.
For negotiate, okay.
Yeah, that works. Thank you.
We can bring out Mr. Good. On Ramos. Okay. I'm gonna stand right next to him.
Mr. Good, good morning. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Affirm.
All right, you can put your hand down, sir. You're before the court on State of Georgia versus Leon Good Jr. 2025 CR 02685 for simple assault and criminal trespass. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is with you at the podium. Sir, you're entering a plea to one or both of these offenses. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, he pleads guilty to counts 1 and 2.
By entering a plea of guilty to counts 1 and 2, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about January 24th of 2025, Officer Ralph Smith was dispatched to the intersection of Highway 85 and Adams Drive, Clayton County, Georgia, in response to a damage to property call involving MARTA bus number 1718 on the route 196 block 3. Upon his arrival on the scene, he spoke to the bus operator, Ms. Precious White, who advised that the defendant, who was intoxicated at the time, boarded the bus and became disorderly by shouting, "I'll shoot this motherfucker," which placed Ms. White in reasonable apprehension of immediately receiving a violent injury. Subsequently, the defendant burst the emergency brake glass and pulled the emergency switch, causing the bus to come to a hard stop. Upon the officer's arrival, the defendant fled the scene on foot and into the street, according to Ms. White. The damage to the MARTA bus was determined to be $10. Your Honor, those are the facts of the case. Your Honor, the state's recommendation for count 1 is 12 months to serve, 180 days, balance suspended. The defendant is to have no contact with the victim, and the defendant is banned from riding MARTA bus 1718. Count 2, 12 months to serve, 180 days, balance suspended. The defendant, again, is banned from riding MARTA bus number 1718, and this is to run concurrent with count 2.
All right, so the bus number versus the route designation is different. So is he banned from riding that particular bus, or is he banned from that particular route?
I would say that particular bus, Your Honor,
Okay,
1718.
all righty. So, Mr. Lynch?
Judge, I have discussed Mr. Good's right to a trial in this case. However, he does want to resolve this case. He understands. He's taking responsibility for what happened. He asked the court accept the plea as negotiated.
All right, he got a right to trial, but don't MARTA buses have cameras?
Well, Judge, MARTA buses do have cameras. Well, the comment I want to make, I probably shouldn't.
I'm just saying. Mr. Good, I'm just saying, on any given day, I'm not messing with a MARTA bus driver because they seem tougher than you. So I'm just saying, you put your life at risk because Miss Precious, she probably been driving for a minute and she's seen a lot of things. And you woke up that morning and chose violence on her bus, and that was probably not the right thing to do, sir. I think you lucky that you got out of there okay. Because I put my money on the MARTA bus driver versus anybody, pretty much. They've seen some things. So what I say to you, sir, is based on this sentence, this tells me that you've been wilding for a minute, because nobody comes to me on the first off, you break something on a MARTA bus, and we talking 180 days. So I'm thinking that you probably been choosing violence for a minute. Because 180 days, sir, that's a lot. Let's address this drinking problem you got. You don't have a drinking problem? You weren't drunk on the date that this happened?
No, ma'am.
You weren't impaired at all?
No, ma'am.
You just decided to get on the MARTA bus and start yelling profanities and breaking stuff?
No, ma'am. It didn't actually happen in that fashion.
Well, tell me how it happened.
On that day, she was running behind and she was not stopping at the bus stops in a timely manner, and she was passing the stop. I want to say I was 100% wrong for breaking the little emergency thing and pulling it, but I don't remember saying anything that she said. Not that I was intoxicated, but because I'm not a violent type person. When you were saying that I've been violent, there's nothing in my history.
Mm-hmm. Okay. But you have a drinking problem?
No, ma'am.
Were you drinking on that day?
No, ma'am.
They just made that whole part up?
Huh?
Said the police just made that part up?
I never spoke with the police and seen the police, and I didn't flee. She had passed my stop, and I was walking to the person that was going to pick me up from the bus stop to take me home.
Okay.
So, like I said, I was guilty of that, and I wouldn't have said that at that time, because just recently before that was when the MARTA bus driver was murdered. So I would nowhere try to intimidate a bus driver, and I ride the bus every day to go to work.
Okay. So if you ride the bus every day, there's a number you can call to complain that they're either not at your stop, or they're running late, or they passed your stop, right?
Yes, ma'am. And MARTA doesn't respond.
I got you.
And like I said, and if I could, I would, if the young lady thought I said something, I would like to extend my apologies to her, because I would never.
Why are we talking 180 days, Ms. Hagler, Mr. Lynch?
Judge, what was that?
Why is it 180 days?
Judge, I had asked for a lesser sentence, and I did discuss.
No, I know you, but the only reason I'm asking this is because I know the situation in the jail. I know the situation where they have way too many people in the jail. And when I'm talking about sentencing somebody to 180 days, I really have to assess whether this is the type of sentence where, it's 180 days, because this is the issue. The sheriff himself, and this is not anything that's a secret, has made it clear that he's short probably 200 COs that he needs to manage the conditions in the jail. What I don't want to do is set somebody up for problems in the jail on a 180-day sentence when there's probably some other people in there who need that space, if you know what I mean.
Well, Judge,
So what I want to know is this sentence driven by his history? What's going on?
I believe, I'll let Ms. Hagler speak because she made the recommendation, but I think it may be based on Ms. Hagler, the offense, the allegations. was
Yeah,
my-
because I'm offended. Whenever you mess with a MARTA bus driver, that's an issue for me. So I understand the 180 days. I understand. Mr. Ms. Hagler?
Yes, Your Honor, the reason for the state's offer was due to the egregiousness of the facts of the case. There were, other people on the bus that day pursuant to police report. So given the egregiousness, given the fact that other people's lives were placed into, at risk, that is the reason for the state's offer. And I don't think that we should compromise, justice, because, based on, what's going on in the jail. But there were other people on the bus that day besides Ms. Precious White. And again, he did damage property on that MARTA bus. So that is the state's position for the 180 days.
Okay. Where do you work, Mr. Good? Or where did you work?
Worked at a Crew Lounge from Chef. It's on Camp Creek Parkway, and I would be working part-time also at Truist Park.
Okay, this is what I want to do. I'll make it a 90-day sentence, but he's banned from MARTA for 12 months. All of MARTA.
Thank you, Your Honor.
And Mr. Good, I'm not really doing this for you, because like I said, I really feel like anybody who causes a problem on public transportation, that's an issue for me. But I'm trying to balance, they say justice should be tempered with mercy. It's not so much mercy. It's more, I understand the overall situation and its reasonableness in this case, because I may need to give that 180 days to somebody who's done something a little bit more serious than you. And I know it's serious, but I got some people who giving folk the beat down, and I mean, those are the folk I need to give the 180 days to. But you're gonna be banned from MARTA, which basically serves the ends of justice that I see. So, Mr. Good, I'm going to accept your plea of guilty to counts 1 and 2, 12 months to serve 90 days. Balance will be suspended as long as you have no contact with the MARTA bus driver, Miss Precious. I didn't get her, I didn't write down her last name.
White, as in the color.
Miss Precious White, and you are banned from all MARTA buses, trains, and facilities for 12 months. On count 2 will run concurrent with count 1, 12 months to serve 90 days, balance suspended as long as you have no contact with Miss White, and that you are also banned from all MARTA facilities and for 12 months. All right, go back with the sheriff's office.
Thank you.
Thank you, Judge.
All right, so I'm going to give y'all some time to talk. This is what I see. So we've done Bender, Bowie, Collier, Crockwell, Lewis, Mitchell, and Ramos are the ones that are outstanding. Yes, sir?
Yes, Judge. No, I was just agreeing. And I think I'm going to have a brief conversation if you want to go ahead and do another plea with Mr. Mitchell. And then after that, just give us a few more minutes and we should have everyone else ready to go.
Is there another plea ready?
Your Honor, Ms. Ramos is is here for a violation of probation, and we're ready to proceed with her.
Okay. All right. So bring up Ramos and I'll be right back. Is that Ms. Chang?
It is, Your Honor.
Good morning, Your Honor.
You can see the recommendation for that. She's in there. I spoke to her briefly.
Okay, let me see if I can, that's 8 Willis. Yeah. I'm gonna text. Can you just mention that, Ms. Taylor?
You want to do it from the computer?
Oh,
Where's it going? Oh, there's Ms. Hagler. Ms. Hagler, we do not have a recommendation for Ms. Crockwell Lewis. I've speak with Mr. Lynch about that. We don't have the police report or the accusation either.
Okay. All right. I'll have someone send it down.
Okay, thank you.
You're welcome.
So other than her, are there any other females? I know you're dealing with.
No, it should just be the two females. Now,
All
because
right, I'm ready for Ms. Ramos. Does she need an interpreter?
she does not, Your Honor.
I think so. All right, Ms. Ramos, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. Is it Yesenia
Yes, ma'am.
Isabel Ramos, 2024 CR 04857. So Ms. Ramos, you're before the court for a petition for revocation of probation. You were before this court and convicted of battery, family violence on the 11th day of June 2024. You were sentenced to 12 months on probation. You have 4 months and 29 days remaining. The sentence was told because you failed to report on November 14th, November 18th, November 21st, 2024, and within 10 days of November 22nd, 2024, as you were directed. You last reported on July 1st of 2024. So it looks like you only did essentially one report. You failed to document proof of enrolling and participating in the Family Violence Intervention Program, and you're $50 in arrears. All right, so Mr. Taylor, what's going on?
Your Honor, Ms. Ramos has had some difficulties with her boyfriend, again with him, basically stealing.
The one she was probably not supposed to have any contact with?
My understanding is that there was
Yeah.
modification that would allow her contact. However, during their difficulties, he would steal her phone and keep her from reporting. That's what I know about the situation. Now I think she's back to a situation where she cannot have contact with him. Is that correct?
Yes, sir.
Where she could what?
No longer have contact with him, the ex-boyfriend.
Well, that was the situation that I thought I imposed the first time.
That may be the case, Your Honor. I don't have any further
Miss
details.
Wright, can Miss Chang, can y'all somebody give me her original sentence right quick, please?
Your Honor, the original sentence is that she's to have no harassing or violent contact with Jonathan Rivera.
All right, where's Jonathan now?
He's no longer in my life.
Oh no, that's not good enough. Where is he?
Oh, he's still in the same location.
Where are you?
525 Museum Circle.
Where are you?
I'm in the same area, but not in the same distance.
Where do you-
Okay, and so you were unable to come in at any time and report.
Yes, ma'am.
Did you have a job?
I was working side jobs like construction.
Okay, were you working construction with him?
No, ma'am.
Okay, so when you were working, you didn't ever think to come in and report or let your probation officer know what was going on?
I didn't have a phone at the moment, and I wasn't he wouldn't let me out of his sight for some reason. I wasn't sure why.
But he would let you go to work.
Because there were side jobs we had around the neighborhood that I would help out with.
But he wasn't standing there watching you.
No, but he would send little females to be watching me from a distance.
What?
I don't understand that part either, ma'am. That's all I've been noticing from him, and he's been distant, but he would still watch over me, if he had an obligation to.
Ma'am, you had an obligation to me to report for probation, to complete your family violence intervention program.
The times I did report, they said that there's a specific number that they told me to call. I wasn't sure if they came and told John that I reported every time.
Ms. Chang, what's the recommendation?
Your Honor, probation recommends that 30 days be revoked and close the case.
Okay. Ms. Ramos, this is hard because you present in the nature of someone who's a victim of domestic violence, even though you were convicted or were pled guilty to battery. But the whole point is, ma'am, that it is a form of domestic violence for somebody to tell you what you can and cannot do. You're a grown person.
Honestly, ma'am, he tempts, like, he scares me a little bit.
Okay, then why did you ask for no violent or harassing contact?
Oh no, that was the first time, but then I started seeing he started getting a little bit more aggressive and a little bit more like just doesn't want to deal with me anymore. So like I don't know what else to do, and he's always watching me.
And he's still always watching you?
When I'm around, yes.
Okay, then there's no place else you can go?
My mother, that's in Covington.
Well, you might, once you finish with this, you might want to relocate because, and when people show you who they are, believe them the first time. You knew what the situation was and you were still like, okay, I'd rather have no violent or harassing contact. Okay, I'm gonna go by your word, but you're the one who knows what really is the problem. If there's alarm bells going off saying, I'm a grown person, but I can't go anywhere, I can't do anything, he doesn't want me to even report to probation because, and I'm risking getting, spending time in jail, bing, 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 red flags, alarms. There's other people out there. He ain't the only one who will ever love you. And that's not love. Somebody who abuses you, who restricts you, who tells you what you can and can't do, what you can and can't wear, who you can see, when you can see them. Well, baby, I'm just trying to protect you. That's not love. That's domestic violence. You would do better by yourself than having somebody, quote unquote, protect you in that way. We clear? Okay. So if you find that he's still around, report him to the police and make sure you get away from him and watch out for yourself. Okay? Because, you know, somebody gonna have send little females to watch out for me. What? For real? I'm just saying, Miss Ramos, if you don't watch out for yourself, how old are you?
I'm 27.
You plan on spending the rest of your life having him look over your shoulder and tell you what you can and can't do? Do you have kids?
Yes, I have an 11-year-old daughter.
Do you have an 11-year-old with him?
No.
Okay, so don't teach your 11-year-old that this is okay. You got me? You're modeling what your daughter is going to get into when she's older. Don't teach her that this is okay. Don't teach her that it's all right to have a grown person be restricted in what they can do, what they can say, where they can go, because there's another grown person telling them what to do, say, or where they can go. That's not appropriate. Where's your daughter now? Who's watching her?
My auntie.
Okay. If she's stable and in a good place, then don't disturb that. Let her be in a good place. Let her go to school. Let her get what she needs. Let her be the person she needs to be until you get yourself together. We clear? Because you're not together yet.
Yes, ma'am.
Now, you're 27 years old. You work in site jobs. What is it you want to do that's going to give you some stability?
I want to become a nurse.
Okay.
And I've been trying to work my way there, but you know, we have to pay all the bills and stuff.
I got you. Start with community colleges. It's Atlanta Municipal College, Atlanta Tech Area Tech, and there are colleges out here that have programs because they're looking for people with nursing degrees or with carer backgrounds. Okay, find a job in a place where you start out as a tech, where they train you to do some of the things that you're going to learn in nursing school. Those are the things that you need to do. But please don't go back, because what we tend to do is go back to what's familiar. the first time somebody tells you they don't like what you're wearing and you can't wear it anymore, the first time somebody tells you you can't have contact with a family member, or the first time somebody tells you you have to be home at a certain time and I'm timing you, and if I call you, you better pick up, red flags, walk away. We clear? Because those situations never end up good. Why does he get to tell you what to do, but you don't get to tell him what to do? All right. So, Mr. Taylor, anything else for Ms. Ramos?
Yes, Your Honor, just that we'd ask that she be credited for the 11 days that she served in custody so far towards the 30-day.
All right, I'll do that. So Ms. Ramos, I'm gonna give you credit since the date of lockup, but I'll revoke 30 days and then we'll close the case. But please remember, ma'am, you too old to give up your life because somebody is telling you they love you. That's not love, okay? And if it feels restrictive, if it feels like you can't be a full adult, then that's not the relationship you should be in, okay?
Yes, ma'am.
Now, there's an old saying that old folks always say, you can do bad by yourself. Why would you do bad with somebody?
Right.
All right. All right. So you're going to go back with the sheriff's office after the service of 30 days. Your case will be closed.
Thank you, Your Honor.
You're welcome.
That's all I have, Your Honor. May I be excused?
Yes, ma'am.
Thank you.
You're welcome.
Judge, we're ready to do a negotiated plea for Mr. Mitchell if Ms. Ponder is ready.
All right. I'm ready. I'm just filling out the paperwork.
Standing right next to me. If this goes off.
1 second, Mr. Mitchell.
I'm guessing that's probably Collier. I don't know. Yeah. And I don't think we've talked to Bender. You want to do him? Bender and Bender. Okay, I'll speak with you.
All right. All right, Mr. Mitchell, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court on case 2025 CR 03144 Marquez Antoine Mitchell. Mr. Mitchell, you're before the court for battery, family violence, count 1, battery, count 2, simple battery, family violence, count 3, and simple battery, count 4. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, she pleads guilty to count 1. I believe the remaining offenses merge.
All right, by entering a plea of guilty to count 1, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am, I do, Your Honor.
All right, factual basis recommendation, please. Hello? Factual basis recommendation, please.
Ms. Ponder, are you with us? Let me send a text to.
Yes, I'm here. Sorry.
I didn't mean to catch you off guard, Ms. Ponder.
Looking for it too. I'm sorry. One second. This is for Mr. Mitchell, correct? Mr. Lynch?
Yes.
Yes.
Your Honor, on January the 28th, 2025, officers responded to 257 Derby Drive, located here in Clayton County, in reference to a domestic disturbance. When officers arrived on scene, they made contact with a Lavette Marcus, who advised her son had been in a physical altercation with her daughter, who was later identified as the victim in this case, Lamisha Mitchell. Lemesha, last name Mitchell, Mittchell. Officers learned during the course of their investigation that there was a verbal argument between mom and defendant. The victim in the case, Miss Mitchell, did try to step in between to defuse the situation. When that took place, the defendant did punch the victim in the face, causing her to have a busted upper lip. Those are the facts of the case, Your Honor. The safe recommendation for count 1 is 12 months to serve, 180 days, balance suspended on the condition that he has no violent or harassing contact with Lamisha Mitchell. Count 2 will merge. Count 3 and 4 will be no pros. Your Honor, that was the negotiated plea.
And Your Honor, one of the reasons, so I did ask on behalf of my client, I did ask Deputy Chief Ponder to recommend a jail sentence. That is because Mr. Mitchell has recently entered a plea and he's going to be serving time. He's going to serve a 1 year sentence, a 5-year sentence with 1 year period of imprisonment, and he wanted to be able to be released without having to have anything else to come back to as far as probation. I believe he has credit for about at least 45 days as to this, Judge, and so that's why we're asking for a straight jail sentence.
How old are you, Mr. Mitchell?
I'm 29, Your Honor.
Okay, where were you living at the time of this incident?
I was actually inside of a mental health facility, Your Honor. I've been shot 5 times. I was in mental health. I was at Riverwoods Behavioral Health Facility before I moved back in with my mother at 257 Derby Drive.
So you're suffering from, among other things, PTSD?
Among other things, Your Honor.
Okay. All right. This makes sense. Okay. Sounds like y'all have worked it out and taken into consideration some things that I would have asked more questions about. Mr. Mitchell, what you've been through, a lot of people don't realize. They think when we're talking about PTSD and other symptoms, we have to be in some kind of combat zone or war situation, but PTSD is a reaction to trauma, and trauma can come from a variety of places. What I ask you to do is to not have shame about your trauma, because a lot of times trauma is unavoidable, but make sure that you remember that just like a medical condition, you just have to be mindful of how, like a physical medical condition, you have to be mindful of how you manage it. If you had diabetes, if you had hypertension, if you didn't go to a doctor and get the right medicine and get the right treatment plan, your body would suffer. It is the same thing. You are not weak because you suffer from PTSD. It is a trauma, and more people have it than are willing to admit it. What happens is when you're willing to admit it and to treat it, that's when you can get better and live a good life. You got me?
Yes, ma'am.
It's not just something that's caused by war or, being in an earthquake or things like PTSD can come from a lot of situations that just regular, ordinary people find themselves in. But it's when you acknowledge that and you treat it like you would any other medical condition that you deal with, you get treatment for it. You be consistent with your treatment. If you find yourself having issues or a crisis, you make sure you get that treatment that you need to come back in. You got me?
Yes, ma'am, Your Honor.
All right. So I'm going to accept your plea. I'll send you, based on your guilty plea to count 1, count 2 will merge, counts 3 and 4 will be no pros, 12 months to serve 180 days concurrent with the case that you've been sentenced on in the felony case that you've been sentenced on. Balance will be suspended. You'll also get credit since the date of lockup on this case, and you'll have no violent or harassing contact with Miss Lamisha Mitchell or Miss Lavette Marcus, okay?
Yes,
You
ma'am.
got me?
Yes,
All
ma'am.
right. Only you can save your life in this situation. And by that, I mean, you got to advocate for yourself and you got to make sure that you get what is necessary to make sure you live a good life, okay?
Yes, ma'am, Your Honor.
All right, take care, sir. Next, or do y'all need time? Bender, Bowie, Collier, Crockwell, Lewis.
Judge, I think we should have something ready to go in a moment, but if you just give us a few moments.
Yeah, that's fine. I'm gonna give y'all a few moments. Y'all knock it out.
You want to go ahead and do Bender?
Yes,
Oh, okay, we're ready on Bender?
that's correct, Your Honor.
All right.
Is there anyone else you talked to that I don't need, like, did you talk to the one lady?
No, she was talking.
Okay. Okay, so yeah.
I mean, I talked to her.
Got you. All right.
Is this negotiated or non-negotiated, Attorney Taylor?
Mr.
Well-
Taylor?
This is non-negotiated,
Okay.
Your Honor.
All right, this is case 2025 CR 03123, Maurice Lamont Bender. Mr. Bender, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. You're before the court for criminal trespass. You're represented by Attorney Taz Taylor. Mr. Taylor, what is your client plea to the offense before the court?
Your Honor, my client pleads nolo contendere to the criminal trespass.
All right, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right. Factual basis recommendation, please.
Yes, Your Honor. On or about November 26th, 2024, Officer Charles Michael was dispatched to 864 Highway 138 in reference to a domestic disturbance. Upon his arrival, he made contact with the victim in this case, Ms. Ernetta, Ernetta Kendrick, Kendrick, who advised Officer Michael that the defendant had taken her car keys to her vehicle, and after a verbal argument, interfering with her ability to drive her vehicle. During the investigation, it was determined that the defendant fled on foot with the keys. It was determined that the victim is the registered owner of the vehicle, and that the defendant and the victim had lived together in the past 3 years. Your Honor, those are the facts of the case. The state's recommendation, excuse me, for count 1 is 12 months probation, 40 hours of community service, a fine of $300, restitution to the victim in the amount of $300, no contact with the victim, and anger management.
All right, Mr. Taylor,
Thank you.
what's the restitution for? Like, did he damage the vehicle?
Let me go back to, I believe she could not, she had to replace the keys.
Oh,
Cause she,
Yeah, that-
yeah, the keys to the car.
sounds about what they cost. All right, go ahead, Mr. Taylor.
I just, we'd asked for a sentence of 45 days to serve. Mr. Bender's been in custody since February, and in addition, he has a violation of probation situation coming up in Superior Court, so he's not going to be able to participate in any of the other conditions that the prosecutor recommended for a probation sentence. Furthermore, it's my understanding that she retrieved, the owner of the vehicle retrieved her keys, and the keys were not found on Mr. Bender's person, leading me to believe that he didn't have the keys to begin with. The agreement or the situation initially started regarding Mr. Bender was working on the alleged victim's or the victim's car, and there was some, I think, disagreement about how that work was being performed or how it was going to be paid for. But this isn't your typical, they knew each other, but it wasn't a situation between two romantic partners, for lack of a better term. It was just a disagreement, and Mr. Bender ran because he was on probation and didn't want to pick up a charge that was going to affect that probation.
Okay, Ms. Hagler, how you see this sentence squaring with his felony probation revocation?
I wasn't aware that he had a felony probation revocation. So, I mean, given that, then that would definitely change the sentence.
All right, so I'm willing to go with the 45 days. I want to do a restitution hearing because I know the keys cost $300 because I replaced keys. That's not the issue. The issue is I thought I heard that she got the keys back in the recitation. So maybe I was wrong.
I mean, no, Your Honor. According to the police report, she informed the officer that the cost to replace the car keys was around $300. So that's on the police report that she got the keys back.
Okay. All right. Okay. All right. This is what I'll do. 12 months to serve 45 days. Balance will be suspended as long as he pays the restitution in the amount of $300. He can pay that through, he can deliver a check to the Solicitor General's office for Miss Ernetta Kendrick. So money order to Ernetta Kendrick in the amount of $300. And you're to have no contact with Miss Ernetta Kendrick. That, like I said, that $300 will be paid directly to the Solicitor General's office through money order.
Thank you, Your Honor.
All right.
Yes, thank you, Your Honor.
All right. Mr. Bender, when you out here trying to be a shade tree, work the terms out beforehand, okay?
Yes, ma'am.
You know what I mean, right?
I know what you mean.
Okay, thank you. Next.
Thank you, Your Honor. You don't have to.
Hey, no step forward.
Judge,
All right, is this Ms. Crockwell Lewis?
this is Ms. Crockwell Lewis. This is going to be a non-negotiated plea, Judge.
All right, Ms. Crockwell Lewis, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yep. Yes.
No, ma'am. No, ma'am. We're going to reset. Okay, so I'm going to treat you with respect. And you're going to treat me with respect. We don't do yep. We do yes, no, yes, ma'am, yes, Your Honor, but not yep. We good?
I mean, yes.
All right, so now, you solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. Now, you're before the court on 2025 CR 03225 for Judy Lynn Crockwell Lewis. Criminal trespass, count 1, disorderly conduct, count 2. You're represented by Attorney Owen Lynch, who's with you. Mr. Lynch, what is your client plea to the offenses before the court?
Judge, we ask the court take no contest pleas on counts 1 and 2.
All right. By entering a plea of no to counts 1 and 2, you give up the right to have a trial by jury or a judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right. Factual basis recommendation, please.
Yes, Your Honor. On or about February 21st of 2025, while conducting patrol on the 3rd floor of the Atlanta Domestic Atrium, located at 6234 Spine Road, Clayton County, also the Hartsfield-Jackson Atlanta International Airport, Officer Pierre, Pierre, Jermil, G as in girl, Ermeil, observed the defendant sleeping. The defendant was observed on the Atlanta airport for at least 2 days. At the time of the arrest, she was sleeping, which is prohibited by the airport. When Officer Jermel walked the defendant up, she admitted that she was not on the Atlanta airport property for employment, and she was not traveling either because she did not have a flight ticket. At that time, the defendant became belligerent, started cursing and yelling. Officer Jermel took the defendant to the Atlanta airport precinct, where the defendant continued to be belligerent, using vulgar language, acting in a violent or tumultuous manner toward Officer Jermel, and putting her finger in his face. Officer Jermel had to push the defendant's hand away from his face. At that time, the defendant was arrested and charged with criminal trespass and disorderly conduct. Your Honor, those are the facts of the case. Your Honor, the state's recommendation for count 1 is 12 months to serve, 90 days. The state has no objection to the defendant getting credit to the day of lockup, balance suspended, and the defendant is to stay away and to not return unless for official business. For count 2, 12 months to serve, 90 days, credit to the date of lockup, balance suspended. The defendant is to stay away and to not return unless for official business, to run concurrent with count 1.
Mr. Lynch?
Your Honor, I would ask the court to consider sentencing her to 12 months to serve 60 days for both, to run concurrent. The reason for asking for that, Judge, I don't believe that Ms. Crockwell Lewis has previously had a airport case, case of criminal trespass at the airport. And I understand the concern with the disorderly conduct, but the officer was the victim in that case, Judge. And so I just think that 60 days would be an appropriate sentence for this case, given her lack of history at the airport, Judge.
Okay. Well, the lack of history is somewhat persuasive, but the fact that you said, well, the officer was the victim. Well, officers deserve to be safe from harm on doing their jobs too. Now, I'm just.
And I understand that, Judge. And I think what I was trying to reference, but is
that she didn't attack a traveler or somebody else. But it's the same thing. That kind of behavior is not acceptable in any context. Well, Lewis, how old are you?
34.
How?
34.
44?
34.
34. Okay, so what's going on? Are you from Atlanta?
No.
Where are you from?
New York.
Okay, what part?
The whole of New York.
No, sir. No, ma'am. There's upstate New York, which is all them little towns upstate, which I can name probably about 30 of them. There's downstate, which is near the city. You're from where?
Brooklyn, New York.
Oh, Kings County Hospital. That's where I was born. Okay. So, ma'am, what brought you down here to Atlanta?
To handle business. I came to actually handle the business and that's it.
Okay. Have you handled that business?
No. No, actually, yes, I have.
Okay. What's the plan? Because Hartsfield Jackson Atlanta International Airport, they're cracking down severely on people just hanging out at the airport because they have no place else to go or because they believe they can get money or food there. They're cracking down on that. And so that's not going to be a refuge for you. So what else do you have going on that's going to keep you out of the airport?
I plan to book a flight elsewhere.
Where? What do you mean? What we talking about?
You said that
You got book a flight money?
I better have book a flight money
From who?
from my form of fixed income.
Okay, so what I'm saying to you is, why are we spending 2 days, 3 days hanging out at the airport and acting out? Do you have family somewhere that can help you? Are you got family in Brooklyn?
Yes.
Okay, so just between me and you, because I know this from a personal standpoint, social services in New York are probably more available and easier to access for someone who may be seeking shelter, someone who may be seeking stability. They're pretty much set up a little bit differently than we are down here. We don't have a whole lot to help. So if you think that you may do better in Brooklyn, I would suggest you get in contact with a family member or somebody who can assist you, because you're going to keep coming up on my radar as somebody who's hanging up at the airport. That's not where you go. Okay. Your business is not at the airport. We clear? Okay. So now that we understand each other, you don't have a history of multiple trespasses at the airport. So this is what I'm going to do. 30 days with credit since the date of lockup. As long as you do not go back to the balance will be suspended as long as you do not go back to Hartsfield Jackson Atlanta International Airport. Now, if you go back to Hartsfield Jackson Atlanta International Airport without a ticket for travel on that day, or without other business in the airport that you can document to a police officer, then if you come back before me, you're going to get a lot more time in the Clayton County Jail. Are we clear?
Right. We'll see.
Okay. All right. So what I would advise you is, if you have family members or support in the Brooklyn area or anywhere in New York City, you might want to do that, because this is not the place for you to not have family support. You can't even get around here because our MARTA system is so much more limited than the metro system in New York. The subway system in New York, the bus system in New York, you can get to every inch of that place. Here, you can't. And so that means that a lot of people end up at the airport because that's the only place to go. What I'm telling you is, it might be easier for you to go back to Brooklyn. We clear?
I feel the same.
All right, then. So we on the same page. Thank you, ma'am. Pleasure meeting you. Go back with the sheriff's office.
So what is the outcome? I'm being released today?
How many days she got on the books?
Should be released today, Judge. I think she's got about
Yeah.
4.
Today's day 40.
Okay, yeah, you can be released, but Miss Crockwell Lewis, please remember you have a unique name, so I remember things, and you don't want to come back before me. We clear?
Right. Very
All right. Thank you. All right, Bowie and Collier.
Yes, Judge. I'm going to go speak to Mr. Bowie, and if you could just give us about a few more minutes, we'll be ready to roll with both of them.
Okay.
Thank you. Your Honor, I do have an announcement for Mr. Bowie.
Ready?
Judge, this is, I have Mr. Bowie here next to me, Judge. So Mr. Bowie does wish to enter a not guilty plea today,
Okay.
although he also wishes to ask the court to set a bond on his case. He is held on this misdemeanor offense with no bond. My understanding is that at the time, the magistrate court did not issue a bond because he was on probation. However, he is no longer a probationer. And I've discussed this with Ms. Hagler, so I believe that she's aware that he is no longer a probationer. Additionally, Judge, the alleged victim in this case is on the Zoom call. So the alleged victim will have which is his son, is logged on as iPhone Bless. So Judge, we would just ask that the court go ahead and set a reasonable bond on Mr. Bowie's case because he is entitled to a bond on his misdemeanor offense, Judge. And he has been incarcerated since March 6th, my understanding.
And Your Honor, the state would object. The defense counsel has not filed a motion to modify his client's bond. We have not been put on appropriate notice. And so the state is not ready to argue for any type of bond. Is not ready for this bond hearing today. So we just ask that the defense counsel will file this motion that way the state can be placed on proper notice and make the proper arguments.
And Your Honor, you're muted. Judge Hayward, you're muted, I believe.
Okay.
Can I respond or did you want to go ahead?
Respond.
Judge, so I think based on the fact that if he's not a probationer, he's entitled to a bond on a misdemeanor offense. The alleged victim is here. I believe it's well within the powers of the court to set a bond for him today. And I believe in the interest of judicial efficiency, there's no, and I don't, I understand she wants me to have to file a motion so that there'll be more time where my client has to sit in jail. But I think we're here today with all the parties. And I would ask that, the court set a bond on his case. And his son is asking to be heard as well through chat.
Your Honor, at this time, again, the state is not ready to proceed on a bond hearing. So we
All
are
right,
not ready.
let me ask this. Does he have a history of violent offenses?
My understanding is no, Judge.
Well, he does have, I did see a few probation violations. That was just from the Cobb County one in 2023. I do see that he has a New York history as well.
I want to know about that. I want to know if in Georgia, in the recent past, last 5 years, does he have any violent history?
1 second, Ryan. Let me go back to the Georgia one. I do see a fleeing attempting. That was 2023, and that's pretty. That would be the most recent in Georgia. But again, he does have out-of-state history, Your Honor.
Okay, he has no bond on any of the 4 offenses?
Correct. And Judge, I don't.
And Your Honor,
No, I'm sorry. Go ahead.
I would just
Okay, stop. Everybody stop. Hold on. First of all, I got a witness texted, chatting, saying he was told he would be allowed to speak. Well, that's only if we have a bond hearing. I'm not sure I'm having one. I'm asking questions right now. Number one. Number two, who's the alleged victim in this case?
That would be his son.
Okay, the person who wants to talk to me?
Yes, Ms. Bless Bowie. I believe that's.
Mr.
Your Honor, I would just ask for a moment to be able to speak to the witness. As it has been stated before, Counsel doesn't represent the victim or any witnesses in this case. His best interest is his client. I think it's inappropriate for counsel to make statements on behalf of the victim in this case. I don't know what conversations that counsel has had with the victim.
At which
It
point
could
did
be
I make a statement
misleading.
on behalf
I'm
of?
sorry, Mr. Lynch. I'm just letting the court know the state's concern. I
Okay.
would ask that if the court is inclined to have any motions hearing over the state's objection, if we can have a moment, so that it is not a motion by ambush by counsel. We were not made aware of this, prior.
All right.
And so I would just
This
ask
what
for
I'm
a
gonna do.
couple of
I'm gonna give
moments.
y'all 10 minutes to talk about talk to whoever you need to talk to. Give me the information you need to talk to on Mr. Bowie, review his record. And then if after that 10 minutes, we'll talk about it. All right.
Thank you, Your
Anything
Honor.
else?
May I have a breakout room with the victim, Ms.
You may.
Hemphill and Ms. Hagler, please?
Sure.
Thank you.
Can I just say one thing?
Sure.
You know, at no point did I make a statement on behalf of the victim or attempt to speak from the victim. I would not do that. I don't appreciate that assertion. I said he wanted to be heard. And that was what his own words on the chat. Didn't make any statements on behalf or purport to represent the victim. Thank you very much.
All right. Gotcha. All right. So I set up the breakout room. It's open. Y'all go in there, y'all talk, and I'll be back in about 10 minutes. Thank you. And then that way we should be ready on Bender also.
I got a invitation to the breakout room, but I'm guessing that was by
Oh, no, I didn't mean that. I don't think you should have gotten an invitation. Hold on. Oh, I think you were already in that I think I already had you there.
And Judge, Ms. Hagler's
Yeah.
still with us, right?
Miss who?
Ms. Hagler, so I did have an announcement on Collier, but I guess I can wait until.
I think I was trying to put Miss Hemphill in there.
Okay.
And Your Honor,
Okay. Yes.
may I be placed in a breakout space with you?
Yeah, hold on a second, Mr. Carmichael. Y'all give me a few minutes. Ms. Powell, can you join the breakout room? I sent a request. All right, we ready? What's going on with, Collier?
Judge, I'm afraid I'm gonna have to send an eval on that case. I was gonna potentially ask him to be brought out before you just because he had wanted to be in front of the judge, but I'm not sure if his,
Okay, is he being medicated?
I did request, and inquire about that, but I believe at this point in the jail, if he's not voluntarily taking it, then, you know.
Yeah, I mean, they can't make him, but yeah.
I did previously email the jail about, making sure that he had that opportunity, but I don't know the status. I would assume not.
Okay, all right. All right, we back on Bowie?
Judge, I don't see I don't see Miss Ponder
Oh,
or,
they're still in the breakout room, hold on.
but I see that perhaps the.
Yeah, I think they're still talking, they're still in the breakout room. All right, we'll be back in a minute. All right, what's going on?
Better roll.
Yes, Your Honor. Again, the state is objecting to proceed forward without a motion being filed, but if the court is inclined to still proceed, the state is ready to proceed.
All right. Mr. Lynch, the state is entitled to have time to prepare. It's not just that they look at his record, which they have access to, but they also entitled to do some research, to talk to people. So when we get these situations, I know he's an active inmate, and I know he's entitled to have his bond reviewed if the conditions for denying him bond have disappeared, but a motion can still be filed. And so to continue to spring these on to the state and then call it judicial efficiency, I just don't think that's fair.
Judge,
Okay. I understand, like I said, I was a magistrate, so I understand 1710-1, 1761, and how bond can be denied in cases such as this. However, they are entitled to the same, I have to be fair to both sides. And so just like you're entitled to bring a motion for bond consideration on behalf of your client, they're entitled to be prepared to argue a motion for bond consideration. And so everything is not an emergency.
well, hold on. Your Honor, I understand the argument about notice, and if that's the court's decision, then that's something we'll live with. However, I'm making a motion to set a bond for my client who's entitled to a bond right now. And I would ask that if you're not inclined to hear that today, that you place it on the next jail calendar so we can be heard at that time. The state has put on notice right now that my client is seeking a bond which he is entitled to. And my client has been held in custody without bond for at least some period, into which our position is that he's entitled to a bond. Judge, I didn't know that he was.
All right, so let me ask you this. So is my understanding. So if magistrate court was disinclined to set a bond based on the fact that he had a prior probation or parole, what happened with that condition? What happened with that?
His probation out of Cobb County has recently been closed, Judge. So he's not currently on probation with Cobb County.
Okay, and when was that closed?
It appears to have been yesterday because he was on a 2-year probation in Superior Court of Cobb County, March 31st of 2023. So yesterday is ended the 2 years as we're in 2025. So it was still in place when the order was signed on March the 7th, though, by Judge Parker, the bond order.
Okay. So he was denied bond on March 7th. The probation just closed yesterday, March 31st. So he wasn't entitled to a bond on misdemeanor under 1710-1 and 1761 until today, is what you're telling me.
Based on the information that I have, yes, Your Honor.
Yeah, so the condition that would have allowed him to have a bond set just went away yesterday.
Correct. But again, the defense counsel still needs to file a motion to put us on notice.
So I don't, the state keeps referencing the defense counsel file the motion. I don't believe they're citing any
Everything okay?
That requires that.
Ms. Hemphill, you need to mute your phone, please. Mute your mic, please.
Oh, you left your money at the house, Kareem, okay?
Ms. Hemphill.
All right.
I'm making a oral motion to set a bond on his case right now. I will file the written motion today, but Judge, I need you to stop talking. Judge, I believe it's well within the power of the court to set a bond.
It is, Mr. Lynch. I'm clear what my power is. They teach us at judge school what power is. I go to the classes, I learn. But the problem is that a lot of times when we have somebody who's in a situation where I get it. I get that the default on a misdemeanor is to grant a bond. I get that. But there are also situations in which the denial of a bond on a misdemeanor is proper. And I know that too, because I was trained on that. So what I'm saying to you is the condition precedent that would have allowed the magistrate court to deny him a bond was still present until yesterday. And so what I'm saying is your emergency does not make an emergency for the state. They still get to do the due diligence necessary to weigh in on whether this person should have a bond. Yes, it's a misdemeanor. And what type of bond he should have, what type of conditions should come with that. They have to, they get the opportunity to talk to the people who witnessed whatever it was, the people who were involved in whatever it was. And so what I'm saying to you is, you would not like to be ambushed in that way when somebody rolls up on you and says, hey, we're going to do this today because, well, I'm bringing it up now, and the judge has it within her power to do. I have a lot of things within my power to do, and my job is to balance it so that I'm fair and I protect the rights, the constitutional rights of the defendants, but I also have to be fair to the state. And what I don't want to get in the habit of is just because somebody's in an orange jumpsuit, it now becomes an emergency because they had a condition that made them not eligible for bond before, but now all of a sudden they're eligible for bond, and I have to jump through hoops because now they want a bond. We're going to put this bond here and off to next week. You'll file the motion today, and we'll start doing that more often than not. Okay, because every time somebody comes up and they don't have a bond down from magistrate court, it does not make an emergency. It makes an opportunity to examine the conditions as to why in a situation where a bond is the default for a misdemeanor, why a bond has been denied. So in this case, y'all can do one of two things. You can negotiate, and now that the condition precedent for denying the bond is gone, you can send over the information and ask for a consent bond, or you can be put on the next available jail calendar, and then we can talk about a bond. And have a bond hearing, but everybody's entitled to notice. And so when you just say, well, it's in your power to do it, judge, but how often am I supposed to just deny them the opportunity that they have to prepare?
And I understand the court's position, Judge. I also think that under the Constitution, pretrial incarceration, is to be, it's not supposed to be punitive in this case.
I'm not saying it's punitive, Mr. Lynch, but I don't know anything about the case. And what I'm asking them to do is opine as to the type of bond they would suggest, the conditions of bond would suggest, the situation having to do with, I just talked to a probationer who, in the situation she's in, she was the one convicted of the battery, but the situation looks like it may have been a domestic violence and she might have been a victim of the situation, but she asked for no violent or harassing conduct. And I'm contacting, I'm going, okay, maybe that's something that should not have been granted in that situation, because it looks like maybe she's the victim. And so I will be more intentional about hearing what I need to hear before I just modify conditions and grant bonds. That's just it. I'm entitled to to have a hearing where people are prepared to argue, just like I did downstairs where I was sitting by designation as a Superior Court judge. We had a time for bond hearings for everything from murder on down, and we had the opportunity for people to prepare for those hearings. Just because it's a misdemeanor doesn't mean the state doesn't get the opportunity to prepare. Everything is not an emergency. And while I respect the fact that pretrial detention is not to be punitive, in a situation where I have to weigh whether there's likely to be another situation between these parties, then I should have the opportunity to hear from a prepared both sides. So just because I can do it doesn't mean I should. And that's the thing that comes with wearing the robe.
And Judge, you
are supposed to zealously advocate for him as your client. And I get that. And I say, do that. But the state also has a client. and they're supposed to zealously advocate for the people. And when I take from them the opportunity to be prepared in a bond here, because I'm gonna just say, well, he's coming up, and I've done it several times, but I need you to understand that that's not gonna happen every time. All right, so he's gonna be put on the next available calendar if y'all work something out between now and then. But yeah, we need to do a sooner one, Miss Val, because of the nature of the detention. But yeah, you need to file that motion today.
Sure, Judge. My client did want me to, my client contests the fact that he was still on probation, but I don't have anything to back that up.
I got that. I'm fine with that. But the whole point is the magistrate court did it right. And the condition that they used to deny him bond didn't end allegedly until yesterday. And so once that ended, file a motion, and then we'll have the bond hearing. But just because it ended yesterday, that does not make an emergency today. Okay?
Hey, you're not helping yourself right now. Judge, at this point, I understand what the court has ruled, and I'm not going to, and I don't think that I'm going to be successful in undoing that. I would just point out that you did say something I agree with. You said just because I can do something doesn't mean I should. And I would just point out that that also applies to the magistrate court when they're denying bonds every chance that they can for any little reason.
But let me explain to you how it works, because I've sat in that seat. When you have a situation where violence is the issue, where it is a battery, a simple assault, as a magistrate, you get 5 minutes to look at the paperwork and to review what a police officer has given you. And we have, as magistrates, access to the criminal file. So the GCIC, when we look at that and we see probation and parole, we don't have the opportunity to call Cobb County and say, hey, let me speak to the probation officer and let me get a full and fair and complete understanding of why he's on probation. What this is, all we know is violence, probation should have the opportunity to opine as to his ability to get out of the situation that he's in. So yeah, no, the magistrate court, when they follow those rules, they're following them to the letter because they are constrained by the fact that a first appearance hearing happens within 48 to 72 hours of the person being arrested. And sometimes it's shorter than that. So they're going on the information that they have at the time, which is appropriate. If all they have is the GCIC and the police report, and it says on their probation or parole, that is the reason 1710-1 and 1761 are in place, because at the time, their first duty is to make safe the community and the person who is the alleged victim in that case, and possibly even the defendant, to keep the peace. And they do that by looking at that. So when you say, well, just because they have the ability to deny, if they had more time, if they had somebody who was prepared to argue a bond hearing at the first appearance, then maybe they wouldn't have to do that. But that is not the mechanism we have. And so what I'm not going to let you do is just decide that the magistrate court, by exercising this legal right that they have, is wrong to do so, because they're not. The whole point is to keep the peace. And if what their indicators say is, hey, we need to slow this down so that the probation or parole officers or the judge involved in those cases can maybe get some notice that here he is, we have him, then that's what they do. Now, this may not be the case where Mr. Bowie is one of the people who their probation or parole officers will be like, okay, we've been looking for him. Thank goodness you got him. Let's slow this situation down so we can review what's going on. But that's the mechanism. And so you don't get to for somebody who's sitting in that seat and who has the limited tools of, I've only got the GCIC and I've only got what the officer has put on this thing. They don't have the opportunity to speak with somebody who's the alleged victim in that case. They don't have the opportunity to speak with somebody who is the probation or parole officer. They only have those tools. And so when you say, well, just because they can, they shouldn't, well, you're saying, they know the whole situation. and they should act as if they know the whole situation when they don't. And I can confidently say it because I did it for 4 years. Okay, so now that I am in the position where I actually get to give some time to review the situation and to determine whether it is appropriate and how much of a bond it is appropriate to set, then yeah, I'd like to be able to get people to be prepared to tell me exactly what I want to know. I can run and gun if I want to, but is the right thing to do? So you zealously represent Mr. Bowie. I will continue to maintain the balance between his constitutional rights and the right of the state to defend the citizens of this county as they see fit. But just because their client is not in jail doesn't mean that they don't have the opportunity to have notice and be prepared for a hearing. Okay? And so we don't just stop every time somebody doesn't have a bond. We need a hearing right now. Not doing that. There may be some cases where it's appropriate, some cases where it's not. We clear? All right. So we're going to reset Mr. And unfortunately, I don't have another hearing date until April 15th. So if y'all work something out, that's fine with me.
I lost everything. And my son is homeless, and I lost everything. My son is homeless, and I lost everything.
Work it out. Because if you don't ambush somebody, then it's more than likely you can work it out. If they have the opportunity to speak with the alleged victim in the case, and they have the opportunity to look at his record, maybe talk to the parole officer or probation officer, and you tell them, hey, this condition just ended, can we work something out? That's one thing. But when you just ambush somebody and say, well, let's push through a hearing, and they're not prepared, they're less likely to work with you. But let's try that. Okay. So this is my understanding that this is Mr. Bowie is entering a not guilty. I'll accept his not guilty. We'll set the bond hearing for April 15th. If y'all come up with something before then I will sign a consent. But that is it today.
Thank you, Judge.
All right. All right.
And Judge,
anything else?
I just want to say, Mom, I didn't mean to imply any malfeasance on the behalf of the magistrate court. My comment is just based on the fact that I see more often than not everyone getting denied bond in any case where
I get it, Mr. Lynch, but what I tell you is, first of all, magistrate court is the busiest, most chaotic court that you can ever serve on. And in fact, it is my honor to have served there because it made me the judge I am today. When I tell you that in magistrate court, you are hit with so much in one day. If you're on criminal, if you're on civil, if you're on intake. So every one of those days is chock full of information, cases, people, review. So when we're doing a hearing like this, and I might have 10 people on my hearing. If you're talking about magistrate court on first appearance, they can have 30 people coming in on first appearance, and they're having to review that information when they get in at 8 o'clock in the morning until the time that they have the hearing. All they have is the GCIC for each person. It is not where they get to spend hours looking at this person's history or their record and then make a decision. We're talking 10 to 15 minutes maybe per person if they have that. And so they are making the most reasoned decision that they can make. And when, somebody who has the benefit of time gets to then say, well, maybe they're saving lives. You ever think about the fact that when they're denying a bond, they may be saving a life, but we might not know it? They're doing what they're supposed to do per the law that they have before them, per the facts that they have before them, per the time that they have to deal with the situation before a whole new crop of people come in for the next 24 to 72 hours where they have to have a first appearance hearing in that period of time. And we're not just talking about misdemeanors, we're talking about major felonies. They see everything. Like I said, from murder on down to ordinance violations. And so when you're talking about judges who deal with that volume of cases, who deal with that those levels of cases, and they're able to make distinctions, they're able to put cases where they need to be. If it's a felony and they see that it should be downgraded, they're able to do that. If it's a misdemeanor and they think it should be upgraded, they're able to review that and do that. You can't impugn the ability of the magistrate court and those judges to do what needs to be done in the short amount of time that they do it. So when they err towards keeping people safe and keeping the peace, I can't fault them for that. All right. So that's all I got. Talk to y'all later.
We're not doing Collier.
Oh, I mean, I thought Collier was Collier's gonna need a mental health event.
Okay, so reset. Okay, thank you, Judge.
I'll have that to you today.
Yes, who called me?
I think Lynch just said he would have that to you today.
Oh,